The Harvard program of negotiation, you should all be familiar with Getting to Yes. It is sort of the Bible in some ways. Since then, the Harvard program of negotiation has been very prolific in putting out books on negotiation. Probably 15 or so would be my best guess after Getting to Yes. I included Beyond Reason by Roger Fisher and Dan Shapiro because it's one of my favorites, but there's just a whole lot of information. And all of the books that come out of Harvard, I find, are very easy to read, very easy to understand, and they're chock full of wisdom. All roads lead to Robert Cialdini. Cialdini is, you will find his work on the psychology of influencing people referenced in many, many, many other books. This is the 5th edition of this book. It was originally titled The Psychology of Persuasion, but it's got pictures, it's funny, it's a good, easy read, but Cialdini gives you a lot of real wisdom about how we influence people and how we are influenced by people, particularly ways in which we will automatically respond to certain triggers that people use to get us to say yes automatically. So, highly recommended. Thinking Fast and Slow. I don't see Kay Elliott here. I want to thank Kay Elliott for recommending this book to me. I've loved her for it, and I've hated her for it. Once again, all roads lead to Daniel Kahneman. In my opinion, Daniel Kahneman is like the Charles Darwin of our day. He's like Isaac Newton. He's someone who has turned so many worlds upside down: economics, psychology. He is a revolutionary thinker. The concepts like cognitive biases, heuristics, framing, priming, anchoring, all of these come basically out of Kahneman's work. The only problem, however, is that this is not an easy read. This is a dense, tedious book. Many times I have struggled with reading the same sentence over and over and over again to try to figure out what it is he's trying to tell me. But if you wrestle with it, you will learn a lot. However, if you're not quite willing to take on such a daunting task, Michael Lewis, who of course wrote The Blind Side, The Big Short, he's one of the best nonfiction writers probably writing today. He's written The Undoing Project, and The Undoing Project is about Daniel Kahneman and his collaborator, Amos Tversky, and their sort of life story and how they developed these concepts. Kahneman, for example, was a Jewish child in Nazi-occupied France and had to hide out. And his family traveled from place to place to try to stay safe and secure. And then ultimately, Kahneman and Tversky both migrated to Israel, fought through a couple of wars there, and in the process developed some very revolutionary ideas about thinking. So this is a good way to get your feet wet about the ideas of Daniel Kahneman, and it's just a great read. Herb Cohen, this is one of my favorite negotiation books. Herb Cohen is funny. There are a lot of anecdotes. He is obviously a master negotiator. You will not doubt that after reading the book. And he's just chock full of wisdom and advice about being better negotiators. Okay, so if you want to approach this from the standpoint of studying great historical negotiations, you have that option too. 13 Days in September is a book that we covered in the study group. It was, I think, very well received. It was very interesting. It's particularly interesting in hindsight to read about the dynamics between Jimmy Carter and Anwar Sadat and Menachem Begin, and you get to play Monday morning quarterback. You know, you get to look at this and say, wow, Jimmy Carter did some really smart things and he did some really dumb things. And but it's very instructive and very timely when you think about what's going on in the world today. So one more, another approach to studying negotiation theory is hostage negotiations. Gary Nosner was I believe, the first hostage negotiator for the FBI. He was there during the Branch Davidian crisis. He was there at Ruby Ridge. He was there at many prison uprisings and whatnot. And he gives you a very candid description of what the FBI has done right, what the FBI has done wrong, when they screwed up, how they work with their tactical teams. Sometimes it works, sometimes it doesn't, but a lot of good stories. And it's interesting to me to read about, and I know we don't do hostage negotiations, but it's, in family law, it's kind of similar sometimes. It's hard to distinguish. But a lot of the techniques that they use with the FBI, and he talks about how they train negotiators, how the FBI trains negotiators. A lot of them are very similar to the same techniques we use as mediators, active listening, for example. There are the use of empathy. There are a lot of similarities in what they do and what we do. Okay, we all know that the negotiation process is basically can be broken down into three areas: pre-bargaining, bargaining, and closure. I'm going to talk next, I'm going to start at the end and talk about closure and sort of work my way backwards, because I think that closure is a topic that we need to be addressing more carefully. So one of my aphorisms that I preach to clients is don't blow the end game. I find that more often than not, lawyers as negotiators, we spend not nearly enough time on the pre-bargaining phase, most of our time on the bargaining phase, and then we sort of leave it all on the field in the bargaining phase. We dump all of our energy and emotion and time on the bargaining phase, and then we get to the end game and it's just like, well, let's just sign something and get out of here. We don't give enough attention to that. We don't think about what kind of closing strategy should we be devising here. Do we want to close or don't we want to close? You go to mediation. Do you want to close? Is that why you're going? Or are you just going because you want to find out what the best offer is, and maybe you have enough leverage that you can be a little coy, and you might want to close later. And then the question becomes, okay, if you want to close, how do you close? One of the things that has always blown my mind in family law cases is that, and I believe this is unique to family law cases, the lawyers who come to family law mediations want the mediator to prepare the closing document, the mediated settlement agreement. Now, that is the dumbest idea in the world as far as I'm concerned. When I'm an advocate and I'm representing a client at mediation and I'm going to close, I'm taking my closing document, and I've gotten in some pretty serious arm wrestling matches with mediators who say, well, I always prepare the MSA or the settlement agreement. Not in my case, you don't. I had one case with big complicated tax issues. I had my agreement prepared, a decree actually prepared, coming into mediation, had talked to the $1,000 an hour tax lawyers to vet the language. The mediator was not going to touch my agreement. And look, as mediators, we don't care. I mean, we're just trying to close a deal. If it's screwed up, then, it's your malpractice, not ours. So I don't know why we do that, but we typically don't even think about a closing strategy. When I talk to clients or lawyers about what's your closing strategy, I get the deer in the headlights look. I mean, they don't think about it. Okay, then a few truisms. We all know this. Understand that fair is a range. Strive for a wise agreement. What's a wise agreement? Anyone? Comes right out of getting to yes. Wise agreement is one that addresses all the interests of the parties. Underline, italics, interests. Pay attention to details, but don't sweat the small stuff. Well, we've all had that experience, right? Where somebody wants to fight over some semicolon or some nitpicky little deal, and all it's doing is it's delaying closure. Sometimes they have psychological reasons that they don't want to close, but don't sweat the small stuff. Don't neglect emotional closure. Now, I know we do this in family law cases. I suspect that it's being done in civil cases as well. If you've got a case where the parties will never see each other again, insurance company, party making claim, you don't have to worry about this. Otherwise, if you neglect emotional closure, it's going to come back. Somehow it's going to come back. So that, and in family law cases, my experience is the mediators just want to deal with the legal issues. They don't want to address the underlying emotional issues. And when that happens, if you've got kids involved, that petition to modify is going to get filed, a year or two down the road, it's going to come back. Ziff's principle actually got this concept from a book called Trump-Style Negotiation, which was written by Donald Trump's lawyer, who used to be on his show, which I didn't watch very much, so I couldn't tell you his name. And in the book, he calls it Ziff, Z-I-F-F. I think a quick look at Google will tell you that it's Z-I-P-F is the correct way to spell it. And what does that mean? I use this idea a lot. So let's say you've got a 40-page decree or a lengthy closing document. Ziff's principle says that essentially, and this echoes the thoughts of Daniel Kahneman, that we're lazy, basically. We get lazy-minded. We don't want to read all that stuff. And you don't want people to read all that stuff. Another one of Kahneman's principles is, he calls it the principle of cognitive ease. Make it easy on people. So you give them one page of bullet points. Here's an executive summary of the closing documents. And he says, and Professor Ziff, his theory was that most people won't, if they trust you particularly, they're not going to spend an inordinate amount of time reading the details. If nothing else, they'll appreciate the fact that you've given them a summary. So I find that very helpful. I use it not only in closing, but also in making offers. Okay, getting down to my favorite topic, MSAs in family law cases. I've about gotten to the point where I just won't sign one. I just won't sign one. It irritates everyone if I'm involved, but as a lawyer representing a party, I won't sign one. Why is that?